The snow and the sleet, it stopped falling several days ago, but still, this is what the sidewalk looks like at my coworker's apartment complex in Greensboro. And this over here, this is the parking lot. The walkways, the parking lot, nothing's been touched. It's a slushy, icy, and dangerous mess. North Carolina requires a landlord to provide what's called a fit premises. In fact, the statute reads, keep all common areas of the premises in safe condition. What it doesn't spell out is a timeline or how to make that happen.
There's no law you have to plow. There's no law you have to put down ice melt. But the law is you have to keep common areas reasonably safe and passable. Landlords are allowed a reasonable time and reasonable expectations depending on the condition.
Attorney David Daggett says reasonable isn't defined. It depends on the circumstances of what another landlord would reasonably do under similar circumstances. But that doesn't mean that you, the tenant, can't make a reasonable request for information about the conditions and when they will be fixed. It can be as simple as a text or an email to the office manager or the property owners.
They can contact the regional or local housing authority. They can, complain, document those complaints in writing. At some point, you could be entitled to some abatement of rent or other charges if the landlord is not doing their duty.
In some triad cities, there's an additional snow ordinance. For example, this is the city of Greensboro. It has an ordinance that talks about the removal of ice and snow. It even says that the landlord should remove it by 10 o'clock each day. I got to tell you, though, this ordinance really has no teeth. No city department enforces this. Snow removal is seen as a private matter between landlord and tenant. So here's my suggestion to you. Get with those other tenants and make some noise. You need to email, you need to text your office manager or your property owner. You need to put those complaints in writing.